Hello friends, welcome to iExamBee. We had started free mock test series on our LegalBee YouTube channel in which we are discussing questions from important sections of various apps. And today we are going to discuss questions from Code of Criminal Procedure, process to compel production of things. This is related to section number 91 to section number 105 of the Criminal Procedure Code. So starting with the first question, complete the sentence with the correct option. In order to require the production of a thing or document, court may issue a written order, court may issue a summon or written order, the officer in charge of a police station may issue a written order, the officer in charge of a police station may issue a summon, and both A and C. The correct answer here is C. The officer in charge of a police station may issue a written order. According to section number 91 of Criminal Procedure Code, summons can be issued to produce a document or other thing. A court can issue a summon while officer in charge of police station can issue a written order. So court and police officer both can issue some document to call upon any person to produce a document, but courts summon issue करते हैं और officer in charge of police station written order issue करता है. Whenever any court or officer in charge of police station considers that the production of any document or other thing is necessary or desirable for the purpose of any investigation, inquiry, trial or other proceeding under this code, by or before such court or officer, such court may issue a summon or such officer may issue a written order to the person in whose possession or power such document or thing is believed to be, requiring him to attend and produce it or to produce it at the time and place stated in the summons or order. Question number 2. In which of the following circumstances can a search warrant be issued? There is reason to believe that summoned person will not produce the document. General search or inspection is required for investigation. Whereabouts of the required document are not known. Both A and C, all ABC. The correct answer here is E, all ABC. In all the three circumstances, search warrant may be issued as per section number 93 of the Criminal Procedure Code when search warrant may be issued. Wherever any court has reason to believe that a person to whom a summon order under section 91 or a requisition under subsection 1 of section 92 has been or might be addressed will not or would not produce the document or thing as required by such summons or requisition. तो अगर कोर्ट को ऐसा लगता है कि डॉक्यूमेंट नहीं लाया जाएगा या फिर डॉक्यूमेंट और थिंग इज नॉट नोन टू द कोर्ट टू बी इन पोजेशन ऑफ एनी पर्सन, पता ही नहीं है कि वो कहाँ पर है, और where the court considers that the purposes of any inquiry, trial or other proceeding under this code will be served by general search or inspection, then it may issue a search warrant. Question number 3. Who among the following cannot issue search warrant to search a place suspected to contain stolen property, forged documents, etc.? The correct answer here is C, Chief Judicial Magistrate. This is given under section number 94 of Criminal Procedure Code, जिसमें ये बताया हुआ है कि अगर कोई ऐसा प्लेस है जहाँ पर स्टोलन प्रॉपर्टी या फॉर्ज्ड डॉक्यूमेंट्स हैं तो उस प्लेस की सर्च के लिए ऑर्डर कौन दे सकता है. डिस्ट्रिक्ट मजिस्ट्रेट कैन गिव, सब डिविजनल मजिस्ट्रेट कैन गिव और मजिस्ट्रेट ऑफ फर्स्ट क्लास. प्लीज नोट, यहाँ जुडिशियल मजिस्ट्रेट ऑफ फर्स्ट क्लास नहीं है, दिस इज मजिस्ट्रेट ऑफ फर्स्ट क्लास. And they may by warrant authorize any police officer above the rank of constable to search such place. Question number 4. Who has the power to declare certain publications to be forfeited? State government, High Court, Chief Judicial Magistrate, Executive Magistrate or District Magistrate? The correct answer here is A, State Government. किसी भी पब्लिकेशन को फॉरफिटेड डिक्लेयर करने की पावर स्टेट गवर्नमेंट के पास है. ये आपके सेक्शन नंबर 95 ऑफ क्रिमिनल प्रोसीजर कोड में दिया हुआ है. Power to declare certain publications forfeited and to issue search warrant for the same. अब यहाँ पर ये देखिए, पब्लिकेशंस को फॉरफिटेड डिक्लेयर करने के लिए स्टेट गवर्नमेंट के पास पावर है, और अगर कोई सर्च वारंट इशू करना है इसके एस्पेक्ट में तो वो मजिस्ट्रेट के पास है. Let's have a reading. Where any newspaper or book or any document wherever printed appears to the state government to contain any matter, the publication of which is punishable under section number 124A or 153A or 153B or 292, 293 or 295A of the Indian Penal Code, the state government may by notification stating the grounds of its opinion declare every copy of the issue of the newspaper containing such matter and every copy of such book or other document to be forfeited to the government, and thereupon any police officer may seize the same wherever found in India, and any magistrate may by warrant authorize any police officer not below the rank of sub-inspector to enter upon and search for the same in any premises where any copy of such issue or any such book or other document may be reasonably suspected to be present. So magistrate will give the search warrant to any police officer not below the rank of sub-inspector to enter and search the premises, and state government will give the order to forfeit the document to the government. Question number 5. A declaration of forfeiture under section 95 of CrPC can be set aside. तो स्टेट गवर्नमेंट ने डिक्लेयर कर दिया, बट अगर किसी को अपील करनी है या वो डिक्लेरेशन कौन सेट असाइड कर सकता है? बाय मैजिस्ट्रेट इशूइंग सर्च वारंट, बाय चीफ जुडिशियल मैजिस्ट्रेट, कोर्ट ऑफ सेशंस, हाई कोर्ट और स्टेट गवर्नमेंट. द करेक्ट आंसर हियर इज हाई कोर्ट. ये आपका सेक्शन नंबर 96 ऑफ क्रिमिनल प्रोसीजर कोड में दिया हुआ है. एप्लीकेशन टू हाई कोर्ट टू सेट असाइड डिक्लेरेशन ऑफ फॉरफीचर. Any person who is having interest in that newspaper, book or other document in respect of which a declaration of forfeiture has been made under section 95 may, within 2 months from the date of publication in the official gazette of such declaration, apply to High Court to set aside such declaration on the ground that the issue of newspaper or book or other document in respect of which the declaration was made did not contain any such matter as referred to in subsection 1 of section number 95. 2 महीने के अंदर अंदर अगर किसी का उस न्यूज़पेपर, बुक या डॉक्यूमेंट में इंटरेस्ट है तो वो हाई कोर्ट के पास एप्लीकेशन फाइल कर सकते हैं टू सेट असाइड द डिक्लेरेशन ऑफ फॉरफीचर. Every such application shall, where the High Court consists of 3 or more judges, be heard and determined by a special bench of High Court composed of 3 judges. तो मिनिमम 3 जजेस का बेंच होना चाहिए, और अगर कहीं हाई कोर्ट में 3 से कम जजेस हैं तो all the judges should be present in that bench to decide on the application for setting aside the declaration of forfeiture. Question number 6. Which section of CrPC corresponds to the writ of habeas corpus? 95, 96, 97, 98, 99. The correct answer is C, 97. Section 97 of CrPC talks about search for persons wrongfully confined. अगर किसी डिस्ट्रिक्ट मजिस्ट्रेट, सब डिविजनल मजिस्ट्रेट या मजिस्ट्रेट ऑफ फर्स्ट क्लास को ये लगता है that a person is confined and confinement amounts to an offence, he may issue a search warrant and the person to whom such search warrant is directed may search for the person so confined. And once the person has been found, he shall be immediately taken before a magistrate who shall make such order based on the circumstances of the case as seems proper. इसके साथ एक और सेक्शन है, सेक्शन नंबर 98 ऑफ क्रिमिनल प्रोसीजर कोड, विच टॉक्स अबाउट पावर टू कंपेल रीस्टोरेशन ऑफ एब्डक्टेड फीमेल्स. तो अगर किसी ने कंप्लेन की है अबाउट द एब्डक्शन और अनलॉफुल डिटेंशन ऑफ अ वुमन, फीमेल चाइल्ड अंडर द एज ऑफ 18 ईयर्स फॉर एनी अनलॉफुल पर्पस, तो उस केस में भी डिस्ट्रिक्ट मजिस्ट्रेट, सब डिविजनल मजिस्ट्रेट और मजिस्ट्रेट ऑफ फर्स्ट क्लास, दे मे मेक एन ऑर्डर फॉर इमीडिएट रीस्टोरेशन ऑफ सच वुमन टू हर लिबर्टी or of such female child to her husband, parent, guardian or other person having the lawful charge of such child, and may compel compliance with such order. Question number 7. Can a criminal court impound any document produced before it? The correct answer here is A. Yes. This is given under section number 104 of Criminal Procedure Code, power to impound document etc. produce. So yes, this criminal code does have the power to impound any document or thing produced before it. Question number 8. Can a magistrate direct search in his presence? Yes. Of any place in India? No. The magistrate can only issue a search warrant. Yes. Of any place for which he can issue a search warrant? No. Only police can direct search of a place. None of the above. The correct answer here is C. Yes, magistrate may direct search in his presence and also to that place where he has jurisdiction for which he can issue a search warrant. This is given under section number 103 of Criminal Procedure Code. Question number 9. If the seized property is subject to natural decay and the value of property is less than dash, the superintendent of police may order sale of the property by auction. Here, the correct answer is C, rupees 500. तो अगर कोई प्रॉपर्टी सीज की गई है एंड दैट इज सब्जेक्ट टू नेचुरल डिके और उसकी वैल्यू रुपीज 500 से कम है, तो सुपरिटेंडेंट ऑफ पुलिस में ऑर्डर कि उस प्रॉपर्टी को सेल ऑफ कर दिया जाए बाय ऑक्शन. ये आपका दिया हुआ है सेक्शन नंबर 102 ऑफ क्रिमिनल प्रोसीजर कोड. इसमें अगर आप सेक्शन नंबर 102 देखो, दैट इज विद रिस्पेक्ट टू पावर ऑफ पुलिस ऑफिसर टू सीज सर्टेन प्रॉपर्टी. तो अगर किसी पुलिस ऑफिसर को ऐसा लग रहा है कि कोई प्रॉपर्टी स्टोलन है और कुछ ऐसे सर्कमस्टांसेस में कोई प्रॉपर्टी मिली है जिससे सस्पेशन हो रहा है ऑफ द कमीशन ऑफ एनी ऑफेंस, पुलिस ऑफिसर में सीज सच प्रॉपर्टी. और अगर मान लो ये कोई सबऑर्डिनेट ऑफिसर है टू द ऑफिसर इन चार्ज ऑफ पुलिस स्टेशन, then he will forward his report of seizure to that officer. इन केस वो प्रॉपर्टी इतनी बड़ी है कि वो कन्वीनियंटली ट्रांसपोर्ट नहीं की जा सकती या फिर उसके लिए प्रॉपर अकोमोडेशन चाहिए उस प्रॉपर्टी की कस्टडी के लिए विच इज़ नॉट अवेलेबल विद द पुलिस, या फिर कोई इन्वेस्टिगेशन के पर्पज के लिए उस प्रॉपर्टी को रिटेन करना ज़रूरी नहीं है. In that case, the police officer may give custody of that property to any person on his executing a bond undertaking to produce the property before the court as and when required. और अगर वो सब्जेक्ट टू स्पीडी एंड नेचुरल डिके है और उसके वैल्यू ₹500 से कम है तो सुपरिटेंडेंट ऑफ पुलिस में ऑर्डर फॉर द सेल ऑफ प्रॉपर्टी बाय ऑक्शन. Question number 10, last question. Power of police officer to seize certain property is given. This is given under section number 102 of CrPC. ये हमने पिछले क्वेश्चन में भी पढ़ा है. Power of police officer to seize certain property जो या तो suspected है to have been stolen or there is a suspicion that that property has been used for this commission of any offense. So this was all from this chapter of CrPC, section number 91 to section number 105. आई विल एडवाइस यू कि एक बार आप जाकर इन सेक्शंस को बैराट से पढ़ लो ताकि आपकी क्विक रिविजन हो जाए साथ ही साथ. वी हैव अ लॉट ऑफ कोर्सेज रिलेटेड टू सेबी लीगल, AIC लीगल, IBPS SO लॉ, जुडिशरी, ADA at our website. You can check out our courses at www.iexambee.com. You can activate the demo and check out our content. We provide crisp and concise content and that is why we say we help you prepare 50% faster. आपको summary sheets भी मिलेंगे जिसके थ्रू बहुत easily आप quick revision कर सकते हैं. There are a lot of practice questions which can help you retain whatever you have studied and do your best in the exam. If you have any queries or suggestions, you can write them down in the comment below. Also, for any guidance and direction, you can call us on this number. Subscribe to our channel. Stay tuned for information relating to law exams and relevant content. Thank you.